Hello, this is Angela Harders, PMA Consultant, bringing you the truth about PMAs today. In our last episode, I shared about how many supposed PMA experts kind of copy and paste this sentence that the private domain is a sanctuary, and they take that statement supposedly quoting from a court case, Pierce versus Society of Sisters. I walked you through that court case, showing you how that statement that it is a sanctuary does not exist in that court case, but I found it. Today we're going to take a look at the next phrase that people use when they refer to the private domain as a constitutional shelter. And again, just to show you that this is something that many different PMA experts, supposed experts, say, we're going to take a look. I searched for this statement, and wouldn't you know it, David Edwards is number 1 and number 2 again in the Google search. So let's take a look and see what it says. I'm going to zoom in here so you guys can see this a little bit better, and I'm going to do the find tool. So remember, Control F. And we're going to look for the term shelter. And here we go. He says that the private domain is referred to as the sanctuary, which we talked about before, and as a constitutional shelter in Roberts versus United States, and again as a shield in Roberts versus United States. All right, we're going to go back. And on his next website, PMA Power, we're going to zoom in again. And here we go. Shelter. There it is, same copy and pasted sentence here, but same as our previous sentence about the sanctuary from unjustified interference. This statement as well also appears in other websites too. Pro Advocate, which is another one of the most popular PMA proponents, they also use this same sentence in their page as well. It's loading, so we'll give it a second. All right, this is Pro Advocate's page. We're going to zoom in and we're going to look for shelter. Copy and pasted, exactly the same as what we see on David Edwards' website. EBPMA, which we saw from our last video as well, they literally all just copy and pasted the same thing. Shelter, here we go, constitutional shelter, and again as a shield. All right, you can go ahead and Google and look through all of these. I mean, literally there are pages and pages and pages where people have just copied and pasted the same stuff, supposedly talking about the private domain. But today we are going to go back through the court case and see, what is this court case really about? If all of these supposed experts are claiming that this court case is what they're going to stand on to defend their right to privately associate in this supposed private domain, what are they actually talking about in this court case? And we're going to go ahead and take a look together. All right, this is the Roberts versus United States Jaycees court case, and this is what they held. The summary of the judgment here, they held that infringement of the right to associate may be justified by regulations adopted to serve compelling state interests unrelated to the suppression of ideas that cannot be achieved through means significantly less restrictive of associational freedoms. Now, this summary, just this summary alone, when I read this, I was like, is this really the best that we can do to defend the supposed rights of PMAs? This summary here says that the state and the courts upheld the right of the state to infringe on the right to associate. They're saying that the state has a right, that it may be justified by state regulations to infringe on the right of association in order to serve compelling state interests. Just right there, I was like, what on earth? How is it that so many of us have been deceived to think that this is the case that we can stand on as defending our right and our freedom to associate, when literally this case is doing the exact opposite? But let's take a look at the details of this case here. All right, here we go. United States Jaycees is a nonprofit national membership corporation. So once again, This is a corporation. David Edwards and so many others have said that the private domain is when you are unincorporated. But this case here is not talking about an unincorporated association. It is talking about a nonprofit corporation, which means that this corporation is incorporated in a state under the state's laws and rules and their jurisdiction. So this court case is not about PMAs at all. As stated in its bylaws, the goal, the objective of this association is to pursue, actually, hold on, let me zoom in some more. All right. So this says, as stated in its bylaws, the objective is to pursue such educational and charitable purposes as will promote and foster the growth and development of young men's civic organizations. The objective of this organization is specifically including growth and development of young men and their civic organizations. The bylaws establish several classes of membership, including regular and associate members, and they also have local chapters. The regular membership is limited to young men between the ages of 18 and 35, while the associate membership is available to persons that are ineligible for regular membership, principally women and older men. So the regular membership is only for young men that are between the ages of 18 and 35, but women and older men can have what they called associate membership. It says that the associate member may not vote, so they cannot vote, they cannot hold local or national office. 2 local chapters in Minnesota have been violating the bylaws for several years. So this was a private membership association in the sense that they were a private club, a private social club, and 2 chapters in Minnesota, a state, had been violating the bylaws for several years because they had admitted women as regular members. Remember, regular membership was only supposed to be for young men between the ages of 18 and 35, but in Minnesota, they started adding women. As a result, they've had a number of sanctions imposed on them by the appellee, which is the national corporation, including denying their members eligibility for state or national office. When these chapters were notified by appellee that the revocation of their charters was going to be considered, members of both of the chapters filed discrimination charges with the Minnesota Department of Human Rights. They alleged that the exclusion of women from full membership violated the Minnesota Human Rights Act, which makes an unfair discriminatory practice to deny any person the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of a place of public accommodation because of race, color, creed, religion, disability, national origin, or sex. So Minnesota passed this Human Rights Act basically saying that it is illegal to discriminate against people in places of public accommodation. Now, this is very interesting because this is supposedly not a place of public accommodation. This is a private club. And so that's going to be one of the kind of points of contention that we look at, that we see in this case here in particular. So this is before a hearing took place on the state charges, the appellee brought a suit against the appellate state officials to prevent the enforcement of the act, alleging that by requiring the appellee to accept women as regular members, application of the act would violate the male members' constitutional rights of free speech and association. So this was the argument of the national club. They were saying that if we allow women to join the club, then that will violate the male members' constitutional rights of free speech and association. Ultimately, a state hearing officer decided against the appellee, and the district court certified to the Minnesota Supreme Court the question that whether the appellee is a place of public accommodation within the meaning of the act. So again, that question kind of was hinging for them on, are they considered a place of public accommodation? The court answered that question in the affirmative. So they said, yes, this private club is going to be considered a place of public accommodation. And in the course of its holding suggested that unlike the appellee, the Kiwanis Club might be sufficiently private to be outside of the act's scope. So if they were truly operating privately, then they wouldn't be subject to that act of being forced to accept women and to not discriminate against women being members. But they only if they were sufficiently private to be outside of that state act. The appellee then amended its federal complaint to claim that the Minnesota Supreme Court's interpretation of the act rendered it unconstitutionally vague and overbroad. After trial, the district court entered judgment in the appellant's favor. The Court of Appeals reversed that decision, holding that the application of the act to the appellee's membership policies would produce a direct and substantial interference with the appellee's freedom of association guaranteed by the First Amendment. So the Court of Appeals, so the district court said, yes, they have to allow women in. The Court of Appeals said, nope, that's going to violate their First Amendment freedom of association. And so they reversed that decision. And in the alternative, the act was vague and construed and applied. And they said that that act was unconstitutional under the Due Process Clause of the 14th Amendment. So it was the Court of Appeals that reversed the district court's decision. But now they've taken that Court of Appeals up another level. And this is what they concluded. They have held that the application of the act to the appellee to compel it to accept women as regular members does not abridge either the male members' freedom of intimate association or their freedom of expressive association. So they basically said that what they believe as their freedom of association, to say we only want to have men in our private club and we don't have to apply, we don't have to apply this act from our Minnesota state and say that we have to allow women in. They said that does not abridge their right of freedom of intimate association or their freedom of expressive association. Now, this is interesting too, because this is kind of the first case that we're covering where they're talking about this distinction between intimate association and expressive association. And I'm going to get into both of these a little bit later so we can have a better understanding of what those two things mean when we talk about our freedom of association. So it looks like there are two different aspects of our freedom of association. We have a freedom of intimate association and a freedom of expressive association. And like I said, we'll cover that later in this court case. All right. So basically, the courts ruled that they had to accept women as their regular members because that did not violate their freedom of association, even though they believed that it did. Several features of the appellee's organization place it outside of the category of highly personal relationships entitled to constitutional protection and unjustified interference by the state. Local chapters are neither small nor selective, no criteria being employed for judging applicants for membership. Very interesting here. So it says that what has constitutional protection of association is highly personal relationships. Again, we're going to look a little bit more deeper into what that means. So local chapters aren't small or selective. No criteria is being employed to judge applicants for membership. Moreover, many of the activities central to the formation and the maintenance of the association of members with one another involve the participation of strangers to that relationship. Numerous non-members of both genders regularly participating in a substantial portion of the activities. Accordingly, local chapters lack the distinctive characteristics that might afford constitutional protection to their members' decision to exclude women. So here, even though it is a private club, it says that they are lacking distinctive characteristics that would afford them constitutional protections to decide as a private men's membership club to exclude women from membership. All right, here it says Minnesota's compelling interest in eradicating discrimination against its female citizens, an interest which is unrelated to the suppression of their expression, justifies the impact that the application of the act to the appellee may have on its male members' freedom of expressive association. So basically the battle here is between what is the state's rights to make sure that there is not discrimination happening versus what is the club's right to supposedly have their freedom of expressive association. And they ruled that by enforcing this act against discrimination on women, that was not in any way hindering the male members' ability to have their freedom of expressive association. By prohibiting gender discrimination in places of public accommodation, the state The act protects the state's citizenry from a number of serious social and personal harms, assuring women equal access to the goods, privileges, and advantages of a place of public accommodation, clearly furthers the compelling state interests. In applying the act to the appellee, the state has advanced those interests through the least restrictive means of achieving its end. There is no basis for concluding that the admission of women as full voting members will impede the club's ability to engage in the constitutionally protected civic, charitable, lobbying, fundraising, and other activities, or to disseminate its preferred views. In any event, even if enforcement of the act causes some incidental abridgment of the appellee's protected speech, that effect is not greater than necessary to accomplish the state's legitimate purposes. So in this court case, whose priorities are the greatest? The state's legitimate purposes, the state's priorities were voted and decided to be more important than the private club. It says again here, the second thing, the act is not unconstitutionally vague or overbroad. The due process concerns for the void of vagueness doctrine are seriously implicated by the act, either on its face or as construed in this case. All right, we're going to come down a little bit here. It says, again, I encourage you to go back through, read through this entire court case. And I know for some of us, it might take us through reading this through a couple times to fully grasp and understand what's happening in this court case. But it's really important that we can read through these things in their entirety and make sure that we're understanding what's actually going on here. Okay, so I'm going to go ahead and scroll down. We're going to skip over where they're introducing all the people. Okay, here we go. Justice Brennan delivered the opinion of the court, and he said this case requires us to address a conflict between a state's efforts to eliminate gender discrimination against its citizens and the constitutional freedom of association asserted by members of a private organization. In the decision under review, the Court of Appeals for the Eighth Circuit concluded that by requiring the United States Jaycees to admit women as full voting members, the Minnesota Human Rights Act violates the First and 14th Amendment rights of the organization's members. We noted probable jurisdiction, and we now reverse that decision. So this says that the Court of Appeals in the Eighth Circuit, they believed that by forcing a private club to allow women in as voting members, that would violate their First and 14th Amendment rights. But the court actually went and reversed that decision. So let's see a little bit more background here into this case. The United States Jaycees, which are referred to as the Jaycees, founded in 1920 as the Junior Chamber of Commerce. It is a nonprofit membership corporation. Nonprofit private membership corporation incorporated in Missouri with national headquarters in Tulsa, Oklahoma. The objective of their association is set out in the bylaws, and here we have it here. Fostering charitable and educational and charitable purposes, as well as promoting and fostering the growth and development of their civic organizations, designed to inculcate individual membership of such organization and a spirit of Americanism and civic interest, and as a supplementary education institution to provide them with the opportunity for personal development and achievement and an avenue for intelligent participation by young men in the affairs of their community, state, and nation, and to develop true friendship and understanding among young men of all nations. So even though in their bylaws, their purpose clearly states that they are for young men, the court still ruled against them and said that they had to allow women into their private men's club. I encourage you, again, go through and read through this entire court case to understand why the courts voted the way that they did. This court case is absolutely fascinating. And one thing that I did want to point out is when we're looking for this term shelter. So finding this term shelter, it's kind of farther down in the case. Here you can see it's at 619. But I want to read the context of this statement here. It says, the court has long recognized that because the Bill of Rights is designed to secure individual liberty, it must afford the formation and preservation of certain kinds of highly personal relationships. This is the freedom of intimate association, your highly personal relationships, your family, your friends, the people that you marry, who you want to have a child with, all of those kinds of things. And notice that it says there, it must be afforded the formation and preservation of certain kinds of highly personal relationships, a substantial measure of sanctuary from unjustified interference by the state. So that phrase does not actually come from Pierce versus Society of Sisters. It comes from this court case, Roberts versus United States Jaycees. But the example that they include here is the Pierce versus Society of Sisters. So they use that as an example to talk about highly personal relationships. Without precisely identifying every consideration that may underlie this type of constitutional protection, we've noted that certain kinds of personal bonds have played a critical role in culture and traditions of the nation by cultivating and transmitting shared ideals and beliefs. They thereby foster diversity and act as critical buffers between the individual and the power of the state. And again, quoting some other court cases here as well. And once again, they quote Pierce versus Society of Sisters. Moreover, the constitutional shelter afforded such relationships reflects the realization that individuals draw much of their emotional enrichment from close ties with others. Protecting these relationships from unwarranted state interference therefore safeguards the ability independently to define one's identity that is central to any concept of liberty. The personal affiliations that exemplify these considerations and that therefore suggest some relevant limitations on the relationships that might be entitled to this sort of constitutional protection are those that attend the creation and sustenance of a family. This is just blowing my mind. So what they're talking about in this whole paragraph before of what is constitutionally protected, and it's so bizarre to me that they're using Pierce versus Society of Sisters to share about this, but what they're explaining is that these personal affiliations refer to the kind of intimate relationships that deal with the creation and sustenance of a family, such as marriage, childbirth, raising and education of children, cohabiting with your relatives. Family relationships, by their nature, involve deep attachments and commitments to the necessarily few other individuals with whom one shares not only a special community of thoughts, experiences, and beliefs, but also distinctively personal aspects of one's life. So the constitutionally protected freedom of intimate association is referring to your family relationships. Family relationships. Among other things, therefore, they are distinguished by attributes as relative smallness, a high degree of selectivity in decisions to begin and maintain the affiliation, and seclusion from others in critical aspects of the relationship. As a general matter, only relationships with these sorts of qualities are likely to reflect the considerations that have led to an understanding of freedom of association as an intrinsic element of personal liberty. Conversely, an association lacking these qualities, such as a large business enterprise, seems remote from the concerns giving rise to this constitutional protection. Accordingly, the Constitution undoubtedly imposes constraints on the state's power to control the selection of one's spouse. That would not apply to regulations affecting the choice of one's fellow employees. Between these poles, of course, lies a broad range of human relationships that may make greater or lesser claims to constitutional protection from particular incursions by the state. Determining the limits of state authority over an individual's freedom to enter into a particular association, therefore, unavoidably entails a careful assessment of where that relationship's objective characteristics locate it on a spectrum from the most intimate to the most attenuated of personal attachments. We need not mark the potentially significant points on this terrain with any precision. We know only that factors that may be relevant include the size, the purpose, the policies, the selectivity, the congeniality, and other characteristics that in a particular case may be pertinent. In this case, however, several features of the Jaycees clearly place the organization outside of the category of relationships worthy of this kind of constitutional protection. The undisputed facts reveal that the local chapters of the Jaycees are large and basically unselective groups. At the time of the state administrative hearing, the Minneapolis chapter had approximately 430 members, while the St. Paul chapter had about 400. So now at 400 members, they are determined to not have constitutional protections because their membership is considered large at 400. Apart from age and sex, neither the national organization nor the local chapters employ any criteria for judging applicants for membership, and new members are routinely recruited and admitted with no inquiry into their backgrounds. So again, we see here they're not having a selective process for deciding who is allowed to be a member and who is not. In fact, a local officer testified that he could recall no instance in which an applicant had been denied membership on any basis other than age or sex. So there was no other criteria to be a member of this private men's club than the fact that they be a particular age and that they be men, which was the purpose of the club, which is so bizarre. An organization whose only selection criteria is race has no plan or purpose of exclusiveness that might make it a private club exempt from federal civil rights statute. Furthermore, despite their inability to vote, hold office, or receive certain awards, women affiliated with the Jaycees, they attend various meetings, they participate in selected projects, and they engage in many of the organization's social functions. So indeed, numerous non-members of both genders regularly participate in a substantial portion of the club's activities, central to the decision of many members to associate with one another, including many of the organization's various community programs, award ceremonies, and recruitment meetings. In short, the local chapter of the Jaycees are neither small nor selective, and remember, keep in mind they had 400 members, and they determined that was not small or selective. And so because of that, they did not have the constitutional protections of freedom of intimate association. Moreover, much of the activity central to the formation and maintenance of the association involves the participation of strangers to that relationship. And so accordingly, the court concluded that the Jaycees chapter lacked the distinctive characteristics that might afford them constitutional protection to the decision of its members to exclude women. We turn, therefore, to consider the extent to which the application of the Minnesota statute to compel the Jaycees to accept women infringes upon the group's freedom of expressive association. So in that first argument there, they basically destroyed their argument for intimate association and said that they were not intimate because they were not small and they were not selective, not like a family. And now they're going to address their freedom of expressive association. Let's take a look and see what that means. In the second section, we see here an individual's freedom to speak, to worship, and to petition the government for the redress of grievances could not be vigorously protected from interference by the state unless a correlative freedom to engage in a group effort towards those ends were not also guaranteed. According to protection to collective effort on behalf of its shared goals is especially important in preserving political and cultural diversity and in shielding dissident expression from suppression by the majority. Consequently, we have long understood as implicit in the right to engage in activities protected by the First Amendment a corresponding right to associate with others in pursuit of a wide variety of political, social, economic, educational, religious, and cultural ends. And last but not least, in view of the various protected activities in which the Jaycees engages, that right is plainly implicated in this case. Government actions that may unconstitutionally infringe upon this freedom can take a number of forms. Among other things, government may seek to impose penalties or withhold benefits from individuals because of their membership in a disfavored group. It may also attempt to require disclosure of the fact of membership in a group seeking anonymity. A government may also try to interfere with internal organization or affairs of the group. By requiring the Jaycees to admit women as full voting members, the Minnesota Act works an infringement of the last type. So the last type, meaning that they're trying to interfere with the internal organization and the affairs of the group. There can be no clearer example of an intrusion into the internal structure or affairs of an association than a regulation that forces the group to accept members that it does not desire. Such a regulation may impair the ability of the original members to express only those views that brought them together. Freedom of association, therefore, plainly presupposes a freedom not to associate. So basically saying they have a right to decide who they want to associate with. In this case, they only want to associate with men. The right to associate for expressive purposes is not, however, absolute. I'm going to read that again. The right to associate for expressive purposes is not, however, absolute. Infringements on that right to expressive association may be justified by state regulations adopted to serve compelling state interests, unrelated to the suppression of ideas that cannot be achieved through means significantly less restrictive of associational freedoms. This is fascinating. A court actually ruled this, that the state has a right to infringe on your right to associate, and that right is justified for them to be able to pass regulations as long as those regulations will serve compelling state interests. That is what the court concluded. And it says here, we are persuaded that Minnesota's compelling interest in eradicating discrimination against its female citizens justifies the impact that the application of the statute to the Jaycees may have on the male members' associational freedoms. So basically, they ruled that the state's right to prevent discrimination against women justifies the right for them to infringe on the male members of a private club, their associational freedoms. On its face, the Minnesota Act does not aim at the suppression of speech. It does not distinguish between prohibited and permitted activity on the basis of viewpoint, and it does not license enforcement authorities to administer the statute on the basis of constitutionally irrepressible criteria. Nor does the Jaycees contend that the Act has been applied in this case for the purpose of hampering the organization's ability to express its views. So basically, the purpose of the Act against discrimination is not going to prevent the private club from expressing their views. Instead, the Supreme Court explained the Act reflects the state's strong historical commitment to eliminating discrimination and assuring its citizens equal access to publicly available goods and services. Now, this is a key point here. I think a lot of this case hinged on the fact that they were deemed to be a public accommodation because of the way that they were operating their quote-unquote private association. So that's something really important for us to know. If we are going to operate as a private club or a private association, we need to make sure that we are operating in ways that are truly private and exclusive and limited and small. That goal, which is unrelated to the suppression of expression, plainly serves the compelling state interests of the highest order. It blows my mind that people use this court case in particular as a defense of the right of private associations and to show the protections that we have as private associations, because this court case literally is the exact opposite. In this court case, which all of these websites here, all these websites use to defend the quote-unquote freedoms of the private domain and private associations, in that same court case that they use that supposedly defends our private domain, our right to associate privately, this court case did the exact opposite. They said that the state's rights trump the rights of a private organization. This is, I don't know if this is as shocking for you as it was for me, but I had to share this with you because this is one of the many, many, many lies that we have been told One of the many things that have been taken out of context where we're given a little bit of the truth, because the truth is that phrase we see, the whole sanctuary, constitutional shelter, shield, that does show up here, right? We saw this sanctuary aspect. Okay, sanctuary comes from this court case. Constitutional shelter, we see that here as well. Okay, and the shield. Okay, wait, well, it looks like shield isn't in this part, but it talks about shielding dissident. So I guess shield is not in this court case, but they're pulling it out of context. They're taking it out of what it was meant to be. PMA advocates and PMA proponents are taking these court cases and nitpicking and pulling little pieces out of the court cases that support what they want you to believe about the rights and the freedoms of private associations. When in reality, if someone were to just go back and read the actual court case, they would say that this court case, they would see very clearly that this court case is actually proving the opposite. They are actually proving that a state's act that would compel a private men's club to accept women as their members does not abridge their freedom of intimate association or their freedom of expressive association. This court case does not uphold the rights of associations. This court upholds the right of the state. And that's all. I encourage you to go back through again and read through this entire court case. I will have this case linked below so that you can read through the entire thing. Again, it is so important that if we are going to operate a private association, that we know what it means. We know how to operate properly. We know how to operate in ways that are going to be protected, because as we can see, there is a way to operate a private association that does not give you the protections that you think that you have. If you are interested in setting up a private association or a private social club or a private club, or learning about how you can transition your business from public to private, I invite you to book a consultation with me. There are so many supposed PMA experts out there that will tell you all these beautiful things that you would love to hear. And I tell you that because I believed them at one time myself too. And unfortunately, I was deceived. The reality of what these people are sharing about PMAs and private membership associations, it is just not there in the case law. It is just not there. And I'm going to continue this. Series here where I go through the different case law with you so that you can understand the way that our courts have ruled either for or against these different situations, because it is important for you to understand the way that courts are ruling and why they're ruling in the way that they do. Because the truth of the matter is, yes, we absolutely have God-given rights and freedoms. We absolutely have freedoms that are protected by our Constitution, our United States Constitution, as well as our state constitutions. But just because we have a right does not mean that that right is going to be upheld in practice by our government or upheld in the courts of law. And so this is a very important reality for us to face. I truly do believe with all of my heart that God has called us to walk in freedom and to be free. And I hope that you can hear my heart in this. I am not trying to share any of this information with you from a space of fear or from a space of doubt. I absolutely believe that God has called us to walk in freedom, and I do not believe that the government has the authority to do what it's doing to us as human beings, as free human beings that were created in the image of our God. I do not believe that at all. And yet, just because I believe that does not mean that my beliefs and opinions are going to be upheld in a court of law. And so that means that whatever you choose to decide and however you choose to operate, know that there are going to be consequences, both positive and negative consequences. And there are consequences that will happen and there are consequences that may happen. But I cannot guarantee any particular result. I cannot guarantee any particular outcome. I wish that I could, but I do know that if we do not find the bravery within to be able to stand for our rights and to advocate for our freedoms and to defend those rights in a court of law up to the Supreme Court, we will lose those rights. Since our founding fathers established this country, we have seen a gradual whittling away of our freedoms and our liberties, and it is so important for brave men and women to take on the task of standing for their freedoms. And at the same time, I know that there is this very real reality that standing for freedoms and standing for what's right will potentially cost you something, and it could potentially cost you your life. And we all have to decide, what are we willing to pay for the price of freedom? So I invite you to consider that today. Thank you so much for watching this video to the end. I invite you to like this video. Please subscribe to my channel so that you can continue to receive different updates about the other court cases that we're going to talk about and uncover in this series. I deeply appreciate you. As I mentioned, if you are interested in getting a PMA or wanting to figure out, or perhaps someone has already sold you a PMA, perhaps someone has sold you a private health association or a private education association or a private ministerial association or a faith-based ministry or a 508c1a or any of these number of things that people claim to be PMAs, whether they are or they are not. If you have one already, I invite you to book a consultation with me. I would be more than happy to conduct a document review for you, because the truth is most of the people out there that are claiming to write documents for PMAs and to write documents for all of these, different types of entities that they're creating and making up, most of them do not have the protections that they think that they do. And so I am so excited to talk with you and to meet with you and to make sure that your PMA is doing exactly what you intended for it to do, and to make sure that you are not only, your documents are proper, but also to make sure that you are operating properly. In the near future, I will be releasing a course, actually several courses, that will walk you through the different ways to operate properly as a private club, as a charity, and as a church. All right. I will share all those links below, so feel free to check out the description. Thank you so much for watching, and I hope that you have a wonderful day.